Welcome to this lecture in which we're going to be covering Chapter 9 of our textbook. This chapter has two topics, performance and also the topic of discharge with respect to contract law. Naturally, that's what this course is about. These two topics are very closely related, so it kind of makes sense that they would be in the same chapter. We're going to approach performance first, and then we're going to talk about discharge, but I think you'll see how discharge kind of loops back to performance, so it gets to be a little bit of a circle here. So let's begin. Here we go. Let's first of all define our first term, performance. When I think of performance, I probably think of something like this. But that's not really what we're talking about in performance, although it certainly can be. I mean, these two actors, and also I guess these two actors and this actor are probably under the terms of some kind of contract. So they are performing according to the terms of their contract. But outside of the theater, that's not the usual meaning that we have with contractual performance. Typically what we're thinking about in terms of contractual performance looks quite a bit like this, although usually frogs aren't necessarily involved. Okay, so let's see what the definition is. The doing of that which is required by a contract at the time, place, and in the manner stipulated in the contract according to the terms of the contract. So performance is just doing what you said you were going to do. And again, both parties are expected to perform or to comply with the terms of the contract. This is what we call the happily ever after of contract law. This is the usual way that a contract ends. In this case, we have Bobby. He's got a lovely little frog here. He's selling it to Sally, and Sally has $5. Bobby is performing his contractual obligation by surrendering the frog to Sally. Sally is performing under the terms of her contractual obligation by giving Bobby $5. That is a successful contract. Both parties have consideration. I guess you could say that the performance is the completion of the consideration that you promised to perform. Okay, so let's go to our next slide. Sometimes there's a little wrinkle with performance, and we call this wrinkle condition. A condition, and here's our definition of condition. An event not certain to occur which must occur unless its non-occurrence is excused before performance under a contract becomes due. This isn't really a good definition because it's really a definition of condition precedent. I'm using it though because it's difficult to come up with a definition that really captures all of the ins and outs of this topic. So just be aware that while we're using this definition of condition, it's really a more narrowly drafted definition than what we're looking at. So a condition is something that can either cause a duty to arise or stop a duty from arising. And we have kind of three categories here that we're going to focus on: a condition precedent, a condition subsequent, and a concurrent condition. And then we'll talk about these two ideas: express conditions and implied conditions. Okay, so let's get started talking about condition precedent. The first thing that you may notice with this term is that we have kind of a weird wording. In English, we usually put the adjective in front of the noun. So we might say the blue hat. So hat is our noun and blue is our adjective. So we do adjective and noun. That's our usual word order in English. Other languages have the reverse, where the noun goes first and then the adjective comes after it. One of those languages that has the opposite word order as a general rule is French. And keep in mind that while we think about Latin as being kind of the language of the law, in many ways it's really French is the language of the law, because, you know, in 1066 when William the Conqueror invaded Great Britain, he became king and he spoke French. And so the courts for hundreds of years after he became king were conducted in French, or at least Norman French. And that meant that when people spoke in court, it was this type of French, hat bleu, chapeau bleu, I guess is what it would be in French, or some iteration of that. And so we still have remnants of that idea in our court system today. And we see that in condition precedent. Here we have our lovely noun and we have our lovely adjective. Now we can switch this around to standard English. We could say the preceding condition. That means the same thing. But again, if you were to call it the preceding condition, legal professionals would be like, huh? What are you talking about? Because condition precedent is just the expression we always use for this. So I'm not suggesting you change it to a condition precedent, but if the word order kind of throws you for a loop, just think about switching it around so it's a little bit more familiar to your English-speaking ears. Okay, so what is a condition precedent? It's a condition that must first occur for a contractual obligation to attach. I call it an on switch. When the condition happens, the light goes on, the obligation begins. Here's an example of a timeline. We have a contract is signed. We'll say the contract is between Sam and Anne. Sam owns a house. Anne wants to buy Sam's house. They enter into a contract. Anne is going to pay Sam $200,000 for the house. But Anne says, you know what? I'm not sure I can secure financing. I don't happen to have $200,000, so I can only buy the house if I am able to secure financing. So and Sam agrees to this condition. So Anne and Sam enter into this contract with this condition precedent. Does Anne have to buy the house now? No, she doesn't have any obligation to buy the house at this time. Her only obligation is to diligently seek to find financing. But if she's never able to secure financing, then the condition precedent never happens, the light switch never goes to the on position, and she never has to buy the house from Sam. If the condition precedent occurs, she is able to secure financing. At that moment, that's the beginning of her obligation to Sam to go ahead and purchase the house. That's when the light switch turns on. This example that I've given is a pretty common one when individuals are buying houses. If they haven't already been pre-approved for financing, many times they want to have this condition in the contract because what if they can't secure financing? They're not going to be able to buy the house. So the words to look for when you're evaluating condition precedent are words like when or if, on condition that, provided that, subject to, before, after, etc. So you could say, if Anne is able to secure financing, she agrees to buy Sam's house for $200,000. On the condition that Anne is able to secure financing, Anne agrees to pay $200,000 to buy Sam's house, that type of language. So it's useful to have these kind of words in your back pocket so that if you're asked to draft a condition precedent, you kind of know what to look for. Alternatively, if you're asked to evaluate or interpret a contract and you see these types of words, those are indications that you might have a condition precedent. So let's go on and talk about concurrent conditions. This one's super easy, and in fact, this is what really all contracts are. And while technically they are concurrent conditions, in a way it's kind of a silly way of looking at it because it's when both parties have to do something at the same time. So going back here to Bobby and Sally, Bobby, if this is the setup here, Bobby's not going to give Sally the frog unless Sally's going to give Bobby the $5. And Sally's not going to give Bobby the $5 unless Bobby gives her the frog. So they're going to have to happen at the same time. If Bobby shows up without the frog, he's not getting the $5. If Sally doesn't shows up without the $5, she's not getting the frog. So that's how concurrent conditions work. They're going to happen at the same time. And so it requires that kind of timing. Everybody's happy, everybody's done what they're supposed to do. Yay, we've been successful at doing that. And so an example here is at a closing, the concurrent condition of tendering the check, I'm buying it. Let's say Anne is able to secure financing. And so the bank, she has a check from the bank for the amount of the purchase. And of course, then the title and the deed will be tendered to her. So we have that order. If one of these is missing, the other one's not going to happen. Essentially, they happen at the same moment. Again, our textbook loves to share with us additional vocabulary words that are kind of related to the topic, but not entirely. So we have a few real estate terms to kind of throw into the mix here. Closing, this involves completing a transaction, particularly a contract for the sale of real estate. There are other types of closings, for example, a business deal, the purchase or the merger of a business, we would call that a closing. But real estate closings are also another category. So the closing means to complete that transaction. We don't typically use those type of language when we're, looking at, say this. We don't call this a closing, although we could. It's just not commonly done. What's a title? A title is a document that evidences the rights of the owners. That is an ownership right. Sometimes we actually, we say here a document, but actually title transfers even if we don't have a document. And most of the time when we sell something, we don't actually transfer a piece of paper. I mean, we do that with houses, we do that with boats, we do that with cars. But if I were to sell you my pencil, I'm not going to give you any document about it. Just the fact that you have it is the evidence that you own it. If I go to Walmart and buy something, I'm going to get a receipt. So I guess you could call that some evidence of title. But if I don't have the receipt, it doesn't mean that I don't own it. So you don't have to have a document that tells you you own something, but certainly it's a nice thing to have. And certainly we see this with either real estate or high-ticket items like cars and boats. Let's consider the topic of deed. This is a document in which real property or an interest in real property, such as a mineral estate, is conveyed to another. So this is kind of, in some sense, a subcategory of the topic of title. Okay, so now we're ready for condition subsequent. We're going to contrast this with condition precedent. So we said how condition precedent turns the light on. Now we're going to talk about condition subsequent. It's going to turn the light off. The light was on, now it's off, okay? And again, we can do the same thing with the word order, switch these two around, and now we have subsequent condition. That may make a little bit more sense to you. So what is a condition subsequent? In a contract, a condition that occurs after the contract comes into existence. And more importantly, it turns off the contractual obligation. So let's go back and look at that timeline here. So we start at the same place we did before. We sign a contract just like we had here. Contract is signed. There's no obligation here, no duty to perform contract. Now, it's not completely true because Anne has the duty to find financing. We'll say no duty to buy. With a condition subsequent, though, yes, there is a duty. Duty begins. Because in our situation, we don't have a condition precedent. We're going along, duty, 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 and something happens. And this event turns off the duty. No more duty. So condition subsequent turns off, condition precedent turns on. This idea of condition precedent and condition subsequent, I think the biggest source of confusion is keeping the two straight. And again, that's probably the hardest thing to remember. So that's why I think about light switches. Condition precedent turns it on, condition subsequent turns it off. So keep that in mind. Be comfortable being able to distinguish between a condition precedent and a condition subsequent. You can have both in a contract. So we could stack these two and have no duty, and then the condition precedent happens, so then the duty begins, but then the condition subsequent, let me fast forward here, the condition subsequent happens and the duty ends. So it's not that you can only have one condition precedent or one condition subsequent. You could have multiple conditions precedent and multiple conditions subsequent. Okay, so we've talked about our first three things, and these really have to do with kind of the timeline. When does that duty begin and end? So we've seen that here. Now we're going to consider not so much the timeline of when the condition arises and whether it turns on the duty or turns it off. We're going to consider how that particular condition was described or presented. So one is an express condition. Now you might be tempted to think when we say express condition, oh, it's a condition in writing. And certainly it can be in writing, but it doesn't have to be in writing. It could, again, if it's a situation where you can have an oral contract, you can have an express condition that is merely spoken. It has to be, clear to the parties that you're actually entering into an express condition. There are other times, though, where it's implied under the circumstances. I'll give you an example with the condition subsequent. If I let's say I hire Jan to mow my lawn, the understanding is that she's not going to mow my lawn if it's a terrible thunderstorm with lightning and rain pouring down as hard as it can be. Let's say Jan is supposed to mow my lawn at 3 p.m. on Wednesday, but boy, it's coming down buckets at 3 p.m. on Wednesday. I don't want her mowing my lawn. She doesn't want to mow my lawn. So that condition subsequent turned off that duty. I don't have a duty to pay her, and she doesn't have a duty to mow the lawn under those circumstances. So, but maybe Jan and I didn't actually negotiate that or talk about that, but it's obvious under the circumstances that it would not serve either one of our interests to have her go ahead and mow the lawn. So we have kind of two names for that. One is it's an implied condition. Another term is it's implied in fact. It's the facts, the scenario, kind of common sense tells us that wouldn't make any sense. And the law doesn't go around wanting people to do things that don't make sense. And so that's how we end up with this implied condition. Now, of course, an implied condition could be explicit. I mean, we could be very detailed in our contract. So in our contract, we could have a provision that actually says, if it is currently raining, the lawn will not be mowed or something along those lines. But it's not necessarily a requirement that we have that level of specificity. Then we also have something called a constructive condition. And this is going to be implied in law. That's another term for it. And it's a condition that is implied by the court to avoid an injustice or an unfairness of some type. As you can see, these two are in some sense negotiated between the parties. This one's obviously negotiated because they actually are saying the words. This other one isn't directly negotiated, but everybody understands what the deal is with this one. This one, though, isn't negotiated. The court is going to apply this condition under the circumstances. It's going to say, you know what? No, the parties did not plan for this. No, it's not implied under the circumstances, but we're going to apply some common sense and we are going to constructively add that condition. For example, let's say I'm supposed to, or let's say Jan is supposed to mow the lawn. Jan is a sole proprietor. She's the only person who works in her business, and she breaks her leg. Well, I guess you could say it's implied under those circumstances that she's not going to have to mow my lawn, but a lot of lawn services are going to have multiple employees, and if one person breaks his or her leg, we can have somebody else come in and fill in. But in this case, Jan is the only employee of this business. She's not physically able to mow the lawn, or at least she can't without great difficulty. And so the courts would likely say, okay, maybe it's not implied, it's certainly not expressed, but we're just going to add it to the contract because it just feels wrong to us to make Jan hire somebody to perform this function or to make her mow the lawns under those difficult circumstances. So as you can see, the express condition is like this lovely apple. You can see the lovely sharp lines here. The implied condition is more like this, soft edges. Okay, I thought this was a little bit of a funny. Wow, your one condition for getting back together is my one for telling you to stuff it. Spooky. So this is a situation where they're obviously not going to get back together. That's the conclusion of our first go-round with performance. We're going to talk about performance, though, as you'll see very soon in the section on discharge. So let's go on to discharge. We really have two terms here to talk about. We have termination, we have discharge. But we're going to spend most of our time using the term discharge. But just to get us started, let's talk about these two terms. What is termination? It's a method of discharging or ending contractual obligations. So this is a subset or subcategory of the larger category of discharge. For the purposes of this class, though, we're going to treat them as synonyms. So if I'm going to try to say discharge for the rest of this lecture, but if I accidentally start saying termination, just interpret my use of termination to mean the same thing as discharge. I just want to keep it clean and not kind of go overboard with a lot of very specific and granular language that I don't think is necessarily that helpful. So let's talk about discharge. This is the release from a contract either by agreement or by the carrying out of the obligations. So when we say a person is discharged, in everyday conversation, that sounds kind of negative. I mean, you know, let's say you have a sore and it gets infected and you have a discharge. Well, that's not a good thing. Nobody wants pus, right? This is not a happy development. Or let's say you were employed at ABC Company and you were discharged. You're fired, basically, right? This is not a happy thing. So in everyday conversation, the word discharge tends to have a negative connotation, kind of like termination. Who wants to be terminated? Not me, right? That's not a good thing. So the law, or excuse me, everyday terminology would make us think that these are negative things, but in contract law, these are generally speaking good ideas. We want to be discharged because that means we don't have to do anything more. It can arise in lots of different circumstances. We're going to actually present just tons of scenarios where we have discharge, but while the way that we might find ourselves in discharge may not be a happy one, generally the fact of discharge, the fact that we're done performing, is a good thing. We no longer have to do anything more. It's a little bit like graduating from school. You're done. You don't have to do any more. It's completed. You may have failed your courses, but you don't have to do anything more about it, at least not right now. That's the idea. And so think about this term in a positive light. So we can see here that one way of discharging is by carrying out of the obligations. And what is that? Performance, right? So one way to get discharge is through performance. When discharge occurs, it relieves a party to a contract of his or her obligations under the contract. So there's no need to perform anywhere. So you can see how whenever we talk about discharge, lurking behind that is something about what our status is with respect to performance. So we're going to have four different ways we're going to think about discharge. We're going to have Pano, kind of like Plano, but there's no L, unfortunately. So just you might want to imagine an L there and just think about the L as being something without a representation. We're going to talk about performance as being a way we can have discharge. We're going to talk about agreement of the parties as being a way to get to discharge. We'll also talk about non-performance. It's kind of odd that we can have performance as a means of discharge and also non-performance. And then finally, we'll talk about the operation of the law. These are our four ways to get to discharge. And we'll get a lot more granular about each one of these ways. So let's get started. Okay, so one way to get discharge is to do what you're supposed to do. I mean, if your boss says, write that letter, type it up, sign it, and put it in the mailbox, and you do all those things, you write the letter, you type it up, you sign it, you put it in the mailbox, you're done with that job. You have discharged your obligations, right? So doing what you're supposed to means you don't have to do it anymore. going back to our scenario with Billy or Bobby and Sally, if the contract between Bobby and Sally is Bobby is supposed to surrender this particular frog and Sally is supposed to pay Bobby $5, as soon as Bobby gives Sally the frog, he's done. He doesn't have to do anything more. As soon as Sally gives Bobby the $5, she's done. She doesn't have to do anything more. The contract is complete, given the terms. Again, as I said before, this is the way the vast majority of contracts get resolved. Usually people do what they're supposed to. It's, again, the happily ever after of contract law, the world. Everybody gets what they want. Of course, that's not exactly how things always work out. But I think it's helpful to keep in mind that that is the usual way. And while there are exceptions, they aren't, it's easy in this course, or in most of our courses in the program, we talk about when things go wrong. For example, if you're taking family law, my guess is you spend about 90% of the class talking about divorce and child custody disputes and division of property. But of course, most marriages don't end in divorce, right? I mean, a large portion do, but a lot don't, right? And so you might think to yourself, well, gosh, if we'll say 60% of marriages don't end divorce, well, how come we don't spend 60% of family law talking about all the happy marriages out there? Well, guess what? If you are in a family law practice, you don't see those people. Why? I mean, you might see them for an adoption or perhaps for a premarital agreement. I mean, there can be some legal issues that come up that really aren't about divisiveness, but people don't go see attorneys when things are going great. So even though, generally speaking, contracts work out just fine and we're in happily ever after world, very likely in your professional experience, you'll see when things go awry more often than not. So let's talk about what can go awry when we're looking at discharge by performance. One can happen is when one party doesn't perform. Okay, so go back to our story with Bobby and Sally. If Bobby doesn't, let's say Sally pays Bobby the $5 because Bobby says, hey, I've got my frog right over here. If you give me the $5, I'll go get the frog. So Sally is trusting and she gives Bobby the $5. And Bobby doesn't bring back the frog. Bobby just leaves with Sally's $5. Well, in that situation, Bobby has breached, right? What is a breach? It's the violation of an obligation or duty. It's the failure to perform when you were required to perform. So, of course, Sally can sue Bobby under those circumstances. But let's consider a different scenario. Bobby and Sally show up. Bobby has the frog. He shows the frog to Sally, and Bobby goes, I'm ready to give you the frog if you just have your $5 ready. And Sally goes, I don't have the $5. Well, it is their understanding of the contract that it's a concurrent contract. Oh, sorry about this. It's a concurrent contract. They're both supposed to do it at the same time. So Sally doesn't have her $5, but Bobby has the frog. Does Bobby have to give Sally the frog? I mean, under the contract, he's supposed to, but Sally doesn't have the $5. I mean, Bobby is concerned that if he surrenders the frog to Sally, he'll never see the $5, so he doesn't want to do that. Well, this is the circumstance under which he is excused from performing. When the other person breaches, then of course he doesn't have to continue to perform. It has to be a material breach. It can't just be some trivial change. For example, let's say that Sally showed up with $4.99. There's an argument that that is not a material breach. It's just 1 penny less than the amount she's supposed to have. An argument could be made that Bobby should go ahead and surrender the frog, take the $4.99, and then Sally should pay him the extra cent as soon as she gets it. I guess reasonable minds can differ, but you could see how you might say that's not a material breach, it's a small breach. Let's consider the issue of substantial performance. Substantial performance is an acknowledgement that the real world is complex. There's lots of moving pieces. People aren't perfect. People's relationships with other people aren't perfect. Imagine that Deion Sanders comes to see me, and I'm a contractor, and Deion Sanders wants to build this huge house in Salina, this palace in Salina. And he wants me to be the general contractor, hire all the subs, get everything organized to build this huge, huge house. And he and I negotiate over the terms, and we enter into a written contract, which of course we have to under the statute of frauds. It's very specific. I mean, there's just tremendous details about the particular fixtures and the name brands and the timeline and the companies and all this kind of stuff. I mean, the whole document is over an inch thick with all those specific requirements. Well, I get started on it. I start hiring subs. I have my workers out there. Everybody is doing well. And in fact, we happen to be blessed with very, very few problems. I mean, whenever you have dozens or maybe even 100 people on a work site, and you have people reporting to different people working for different companies, there may even be some language issues from one person speaking one language to another person speaking another language. There may be times where the electrician is where the drywaller wants to be, and all of those things can also happen. So there's going to be conflicts, there's going to be miscommunications, there's going to be disagreements. All of those things are going to happen. You kind of work through those. So let's imagine that we're able to finish the house. Deion walks through the house, and my gosh, it's gorgeous. I mean, everything is immaculate. There's not even a paint spatter anywhere. It's just pristine, perfect, exactly according to the specifications. We go to the kitchen, we go to the master bedroom, we go to the master bath, we go to the first bedroom for one child, then the second bedroom for another child, then the third bedroom, let's say they have 3 children, and then we go to the guest bedroom, and then this room and this room. We go all over this house, and we eventually arrive at the 10th bedroom. Again, it's just beautiful. It's perfect. It's got just the exact color walls that Deion wanted, the exact kind of molding he wanted, the dimensions of the room are perfect. And then we go into the closet, and the closet is great. But Deion notices that the closet is supposed to be 6 feet deep. And this particular closet is only 5 feet 10 inches deep. It's 2 inches short. Now, in terms of functionality, the closet works just fine. I mean, it's a good closet. I mean, it's not going to stop anyone from being able to hang up clothes. I guess since you're losing 2 inches, you're not going to be able to hang up 1 or 2 shirts that you otherwise would have. But other than that, it's perfectly functional. And in fact, no one just walking into the closet would necessarily even know that the closet isn't fully 6 feet deep. Deion sees this and he's livid. He goes, "You've breached the contract. Look here on page 83, paragraph 419. It says that the 10th bedroom's closet should be exactly 6 feet deep, and this is only 5 feet 10 inches deep. This house is a piece of garbage. I refuse to complete this transaction. You're going to have to figure out who to sell it to because I'm not buying it." Well, I would say under those circumstances that this is a situation where we have substantially performed. It's less than perfect performance because it is true that the contract did specify that that closet should be 6 feet deep. But the reality is no place is going to be perfect. It's just not humanly possible with all these people and all these moving pieces to get everything perfect. And we expect to find minor deviations, minor defects in the product. Now, of course, it's possible that that closet being 2 inches short has diminished the value of the house. Let's say the house would ordinarily sell for $20 million. Well, maybe now it'll sell for $19,900,999 and or some equivalent, but it would be a trivial amount of money, maybe $50 or something, to reflect the fact that the closet is 2 inches short. So it's possible that Dion could argue that he deserves a little bit of a break on the price. But the bottom line is we performed just very minor, very small breaches. So in that situation, when you have substantial performance, Dion's performance is not going to be forgiven. He is going to have to go ahead and buy the house, right? If you didn't have substantial performance, you couldn't have a construction industry. I mean, I would never agree to build Dion's house because I know there's going to be problems. And so, if Dion decides not to close on the transaction, how can I possibly find another seller for this house? Because after all, it will include all of Dion's choices. Maybe Dion loves, well, I guess we'll say loves blue and silver, so the whole house is blue and silver. Well, I mean, blue and silver are nice colors, but probably most people don't want that in every single room. And so for me to find someone to buy it, I have to find somebody who wants a really large house in Salina, and I'm going to have to probably take away some of the Dion specific features, so it's going to cost me money. So you can see how if we required perfect performance, that would have to be figured into the price. And so that house that ordinarily might be $20 million might be $30 million if we do require that level of perfection. So this again is discharge by performance. So let's consider, when we're looking at substantial performance, the types of questions that the courts are going to ask. You might look at this house, you might go, well, this looks like a situation of substantial performance. I mean, let's assume that it called for 3 bedrooms, and we have 3 bedrooms, and we've got a kitchen and 2 baths and all those things. But I think most of us would argue that a house upside down, unless it was supposed to be upside down, isn't going to qualify as specific performance. So these are the questions that the courts are likely to ask. And again, no one of these questions controls. It's the totality that's going to be the important part. So what did the non-breaching party expect? This would be Dion in our scenario. Was he really focused on that 10th bedroom's closet? I mean, maybe he was. Maybe there's some really awesome reason why he really needed to be 6 feet. And he communicated that to you and it makes sense. Maybe he was going to have his mother-in-law live there, and his mother-in-law has some very specific medical needs, and the intention was to put this medical equipment in there, and the medical equipment is 5 feet 11 inches, and so it needed to be 6 feet to fit in this room so they could close the door, whatever the specifics might be. Under those circumstances, if Dion had communicated that this was really important and you still didn't do it, then that might be an indication that we don't have specific performance. Is compensation measurable? If the loss is small and measurable, it is likely to be substantial performance. So, how much has this property diminished because that closet is just a touch too small? Probably there's no diminishment in value. But if there is, it's going to be a very, very small one. And that would be an indication that, yes, it's measurable and very, very small. Here is, was the non-performance willful? Did I, the contractor, intend to mess with Dion? Let's say we had had a fight, and I thought to myself, and then maybe I even went to the workers who were working on the 10th bedroom. Hey, guys, I know that closet's supposed to be 6 feet deep, but don't you dare build it that way. Make it only 5 foot 10 inches. I'm going to extract my revenge against Dion. He's really, really annoying me. Let's annoy him by giving him too short a closet. I mean, as soon as I say that, it sounds ridiculous. But if I intended to breach, if I were intentionally setting circumstances up to breach, it's much less likely the courts are going to find substantial performance. When did the breach or delay happen? And this really falls into the delay category. It's pretty common, especially in contract situations, where the breach is things took longer than what was expected. Maybe there was bad weather, maybe there were supply problems, maybe just life happened. Usually delays aren't going to make the case, or excuse me, the matter be considered a material breach, that once it's completed, it's still going to be considered a substantial performance. But there are certain contracts where it might be different. For example, let's say, think about Brazil when they were building all those facilities for the Olympics. Well, it does no good to finish the facility the week after the Olympics are over. So in that situation, you need to have it done by the time of the Olympics, or really there's no point in getting it done at all. And so there are times where the date is important. We oftentimes call those conditions when time is of the essence. And usually that language is going to be included in the contract, and there'll usually be some discussion about why time is of the essence. You know, we need to have this done by this date for this reason. And that way it strengthens the argument of the person who wants that date to be a drop dead date, that, hey, yes, this is really important. Because again, the court's going to be inclined to say, well, you know, as long as everyone's trying, we're going to cut them some slack unless we see a really good reason not to. And again, that language could be the really good reason. So that's our first topic. Discharge may occur by performance, or again, the failure to perform might be forgiven by the other person's breach, which we'll talk about down here. Let's talk about the next category, agreement. And we have 4 categories here. We have rescission, release, accord and satisfaction, novation, and discharge by the contractual terms. So let's get started. So here we have RRAND is how I remember that. Let's talk about rescission. Rescission is the noun form of the verb to rescind. And the word rescind means to cancel. So when we're talking about rescission, we're talking about cancellation. And you can see right here, actually the definition says it. The cancellation of a contract by the act of a party. It may be by mutual consent of the parties. So that would obviously be mutual rescission. If both parties want to cancel the contract, honestly, the courts aren't even going to get involved because there's no need to. I mean, if going back to our situation with Bobby and Sally, if Bob, you know, they enter into this contract, Bobby's supposed to give Sally the frog, Sally's supposed to give Bobby the $5, but you know what? Bobby starts thinking about it, and this is his favorite frog. And Sally's thinking to herself, gosh, this is my lunch money. I don't want to be hungry. And they both decide, I don't really want to do this. Well, guess what? They don't have to do it. Now, if one wants to do it and the other doesn't, then, of course, in that situation, the one who doesn't is very likely to be required to do it. But if neither one wants to do it, then they can shake hands and go about their business, and Sally keeps her $5 and Bobby keeps his frog. There would be no reason for them to complete a transaction that doesn't make sense. So mutual rescission allows both parties to walk away and move on when that situation arises. And of course, the goal is in a rescission is that we return the parties to the condition they were in before they entered into the contract. So Bobby still has his frogs, Sally still has her $5. It could be that maybe Sally prepaid $2 for the frog, and now she only has $3 remaining. And so when they decide to rescind, presumably Bobby's going to have to repay the $2 that Sally prepaid, so that Sally has all of the money that she initially had and Bobby still keeps the frog. So sometimes there needs to be some adjustments in position so that you really return people to the situation they were in before. Generally speaking, a rescission can be done orally. The only time that it can't be is when the statute of frauds requires that it be in writing. So if we're rescinding a contract, say to sell some real estate, well, under those circumstances, since the first contract has to be in writing because it deals with real estate, then the rescission or the cancellation of the contract is also going to need to be in writing. Let's talk about our second R. So here we have rescission. Now we're going to move on to our second R, release. Oops, sorry. So a is the act of giving up or discharging a claim or right to the person against whom the claim exists or against, whom the right is enforceable. Many times these are part of a settlement arrangement. We need to have consideration for the release to be effective. So both parties have to be doing something. The person giving up his or her rights, that's his or her consideration. Typically, the other party is giving up money. So I'm paying you. Let's say we're in a car accident and you feel like it's my fault, and so you are planning on suing me about it, and I say, but wait a second, what if I pay you $5,000 and you agree not to sue me? So my consideration is going to be that $5,000. Your agreement is not to sue me. So we do need to have consideration from both parties. And it's certainly a best practice to have it in writing under those circumstances. So what happens is that the party who is signing the release can no longer sue the other party. It's pretty common in releases to have a mutual release section so that I'm releasing you and you're releasing me, but it's not necessary. It can be a one-sided release. If both parties release the other, then both parties have provided consideration, so there doesn't even have to be a financial payment under those circumstances. So I said before, releases are often mutual, and that's kind of implied here when we say the parties no longer pursue claims against each other under the contract. That's how a release works. Let's now talk about accord and satisfaction. Really, for the most part, this is the same thing as a release. We just have a little bit fancier terminology for it. So accord and satisfaction is kind of a two-part process. So let's look at the definition here we have. An agreement between two persons, one of whom has a cause of action against the other, in which the claimant, this is the plaintiff here, the person with the cause of action, accepts a compromise in full satisfaction of a payment. Okay, so we have the accord, which is the agreement. Right here, that's the first stage. And then we have the satisfaction, which is when the payment is actually paid. So if we have an accord and satisfaction, I agree to pay Bob $5,000, then that agreement, which Bob signs and I sign, is the accord. When I actually pay the $5,000 is when we have the satisfaction. So we consider this a complete transaction, a completed action. Many times these will happen pretty close to simultaneously, but sometimes there's a little bit of an administrative delay between the two. Either way is fine, but it's not a done deal until we get to step 2. So now we have covered rescission, release, and accord and satisfaction. Let's go on and talk about novation. Novation, the way I remember what novation is it's just like innovation if we take off the IN at the beginning of innovation. What is an innovation? An innovation is a new thing, an invention, a new twist on something, maybe something that we've already been doing for a while. Someone's come up with, a better mousetrap or a better can opener or something like that, along those lines. So innovation is the extinguishment of one obligation by another, a substituted contract that dissolves a previous contractual duty and creates a new one. So let's consider an example to kind of make this make a little bit more sense, because what we're going to do is we're going to think about the novations that are what I'm going to call change the party novations, because this is the usual. It can mean something broader, but this is what kind of people in their minds usually think of when they think of novation. So we have here, we'll call this person Bob. Bob is, well, actually, we'll call this person Bob. Bob and Jan enter into a contract. Jan has a lawn service, and Bob agrees to pay Jan $25 a week during the period of time of the year where the grass is growing, and Jan agrees to cut Bob's lawn every Wednesday between 3 and 4 p.m. That is the initial contract. There's no novation involved, that's just the deal. You can see they're both providing consideration. Bob is paying money, Jan is providing a service. There's performance when every week when Bob pays, and there's performance every time that Jan mows the lawn. Unfortunately, Jan breaks her leg, poor thing, and so she is not able to complete her contractual obligations. But she has a competitor, we'll call the competitor Carl. And so Jan reaches out to Carl and says, hey, Carl, I am not going to be able to continue to mow Bob's lawn. Bob pays me $25 a week to mow his lawn. You know, it's on a quarter of an acre, maybe even less than that. We'll say it's a quarter of an acre. It's a quarter of an acre, pretty level ground. We'll say it's a Bermuda grass. Would you be interested in taking over my obligation? Carl thinks it over. He goes, yeah, sure, okay. So now it's for Bob to decide. So Jan now goes to Bob, hey Bob, you know, I broke my leg. I'm not going to be able to mow your lawn anymore. I know you need someone to mow your lawn. How about if Carl replaces me? He's got great references. Here's some testimonials from satisfied customers. He'll charge you the same amount, $25. He even can come out on Wednesdays between 3 and 4. What do you think? Bob says, sure. I mean, honestly, as long as the lawn is mowed well, I don't really care whether it's you or Carl. So that sounds cool to me. So this contract here is the novation. You notice the terms are the same. It's the same lawn. It's the same money. It's even the same time. The only difference is we're switching Carl in for Jan. Okay, when this happens, Jan falls out of the contract. She's no longer part of this. This whole contract actually goes away. So Jan has no continuing obligations under the contract. If Carl does a bad job mowing Bob's lawn, Bob's going to have to sue Carl. Bob can't sue Jan because Bob's and Jan's contract went poof when we had this novation. But of course, Bob can sue Carl, and of course, Carl can sue Bob if Carl breaches. So this is a neat way for Jan to fall out of the situation. We'll talk about assignments in Chapter 11. So bookmark this and realize that there's another way of doing this same thing. I'm not going to talk about it yet, but just know that when we get to it, you'll think to yourself, isn't this awfully like novations? Kind of like novations, but there's some important differences. And so when we get to 11 and talk about assignments, we'll revisit this topic in a little bit more detail. Now, novations have to be supported by consideration. And you can see in this case, there is consideration because Carl is going to mow the lawn and Bob is going to pay Carl. So there's not any consideration problems in this particular case. Let's go to our last one, our last of our RANs, discharge by agreement category. We're going to talk about discharge by contract terms. We've actually already talked about this. Sorry about this. This is when we have a condition subsequent. Again, the example, or maybe I didn't provide an example. Let's go back and look at condition subsequent, and I'll give you an example of one of those. Here we go. Okay, so I enter into we'll go back to our original characters. Sam owns a house, Ann wants to buy it, Ann is going to pay $200,000. Ann has already secured financing, or maybe she has cash. But anyway, we don't have to worry about the condition precedent of Ann securing financing. It's not an issue in this case. So Ann's duty begins immediately, but there's a condition subsequent to the deal. Ann says to Sam, listen, Sam, I'm like 95% sure I can go ahead with this, but you know what? There's been some layoffs at my work. I talked to HR and they say they're going to get through all the layoffs by this Friday at 5 p.m. I think I'm safe, but if it ends up I do get laid off, I'm not going to want to complete this transaction. And so what I'd like to do is I would like to have a condition subsequent, that if I lose my job by 5 p.m. this Friday, I don't have to buy your house. The light switch goes from on to off. I no longer have any obligations. If I still am employed by my employer at 5:01 p.m. on Friday, then the obligation which was already turned on is going to continue being turned on. So that would be an example of a condition subsequent. So let's now go to our D in RRAND. So we have this condition subsequent. Let's assume the condition subsequent happens. I'm unlucky. I lose my job. And so under the terms of the agreement, I have no continuing obligations under the contract. I am excused from performance. That's what a condition subsequent does. So discharge by contract terms occur when, according to the terms of the contract, the parties to duty to perform under the contract has ended. Condition subsequent is a good example of that, but there could be other things. If there, if there's a natural disaster, I don't have to necessarily perform. That might be implied or even a constructive condition under those circumstances. But maybe the contract provides if the price of a particular raw ingredient goes up to a high enough level, then the duty to perform under the contract goes away. There can be lots of different provisions. Pretty common that you would have those possibilities. Maybe you might even have a clause that says that if there's a war or labor unrest, say a strike, that contractual obligations are discharged under those circumstances. Again, parties can contract as they wish, so they can kind of do whatever they want in this area. And the courts are very likely to honor it. So now we've gone through all the situations where we have discharge by agreement. Where there's rescission, usually that's going to be mutual rescission. Where we have release, also we can call that accord and satisfaction. Typically happens when there's some type of dispute where one person is willing to settle the dispute. Novation, when one person wants to fall out and replace that person with another person. And then finally we look to the contract terms. We're looking at a condition subsequent that may or may not be express. And so these are our 5 ways, RRAND, where we can have discharge by agreement. When we're next together, we'll talk about non-performance, discharge by non-performance, and also discharge by operation of the law. So thank you for your attention. As always, if you have any questions, please feel free to send me an email or stop by my office hours. I always like to talk with students, figure out what's on their mind, see how I can add value to them as they are learning about contract law or whatever else. Thank you for your attention. I hope you have a wonderful day.